landlord must provide a clean and safe apartment. So it has to be suitable for living. What the law says, it has to be in good living condition. So that's a fundamental provision of the law. The landlord has to provide you with what the law calls peaceful enjoyment of your apartment, which means that the landlord must make sure that other tenants, or let's say other noise, like loud noise of work being done in the building, doesn't disturb you. The landlord must do repairs. So the law says any necessary repairs. This means pretty much any repair, except very minor things, like, for example, changing a light bulb. You couldn't ask the landlord to do that. Pretty much anything else that you could think of that's a necessary repair, fixing a window, fixing plumbing, that your tap is dripping, your shower is dripping, a light fixture that was there when you arrived that doesn't work, or that fell down or something, the landlord would be responsible for. So let's move to the next slide. Now, what happens if the landlord doesn't respect their obligations? The general rule is you inform the landlord in writing and give them 10 days to fix the problem. This is for repairs that aren't urgent. We're going to talk about repairs that are urgent in a moment. If it's not resolved, so you tell the landlord, my window, somebody broke my window and the cold air is coming in. It's October already. If it's not resolved, actually, that might have been a better example of an urgent repair. So let's say a less urgent repair. My shower is dripping, not like it's not flooding the apartment or anything, but it's annoying. So that would be an example of a non-urgent repair. You give the landlord 10 days to fix the problem. If it's not resolved, you can file at the rental board. You can file an application at the rental board. The rental board can advise you about the different things you can ask for, but among these are an order for the landlord to do repairs, a reduction of rent until the landlord does the repairs, damages for what you've suffered in the past, and if it's very serious and you would like to leave, it could be to cancel your lease. So there's different options that the rental board can discuss with you, and you can choose them. Now, urgent repair. So a classic example would be a burst pipe that's, threatening to flood your apartment, but also somebody, a vandal broke your window, and cold air is coming in, and it's already the middle of October, and we know what's coming because, we live here in Quebec. You would try to contact the landlord. If you can't reach them, or you do reach them, but they say, no big deal, I'll get to it when I get to it. This is a big exception to the general rule. You can actually carry out the repair yourself and deduct the cost from your rent. This is the only situation in Quebec law where you can deduct money from your rent without the authorization of the rental board. So this is quite an exceptional situation, and just for urgent repairs.
Okay, Richard. So I think I'll start with this question. So if landlords don't respect the obligations and the tenant has to inform the landlord in writing that they have 10 days to fix the problem, can that letter can that letter just be written by the person who signed the lease, or could it be written by someone who, for example, has a power of attorney?
It could be written by someone who has a power of attorney. Okay. And in fact, if you really want to show you're serious, you can have a lawyer write the letter, which lawyer's acting as your representative. But if you have given a power of attorney to, let's say, an adult child or a brother or sister, absolutely. But they should specify that they have power of attorney and attach a copy of the power of attorney. Otherwise, the landlord has no way to know that it's true. It could be somebody who's just interfering in your affairs.
Do the rules that you presented for landlords and tenants, do they still apply to HLM, to low income housing as well?
Yes, but except, well, we didn't touch. I think that everything I've talked about, which is repairs, for example,
Mhm.
disturbances, and so on, absolutely that applies. The municipal housing office is a landlord, just like a private landlord, except they're part of the municipal government. What wouldn't apply, but it wasn't the topic of today, is the rent control is completely different. It's not set by the rental board. It's set according to your income. You
Mhm.
pay basically 25% of your income is calculated as your rent. But aside from that, they're a landlord like another landlord.
Um, so just to clarify, when you said urgent repairs, the tenant can do them, but then they deduct the cost from the
Mhm.
rent. What are the steps that they have to do to prove that they paid for them, for those
Okay.
repairs?
So, but the whole process is very important because you have to try to reach the landlord. So there's many scenarios. You could reach the landlord and tell them, and the landlord says, I'll get to it when I get to it. You could get an answering machine and then leave a detailed message, or you could get no answer. But you have to try. Once you've done that, and the landlord isn't moving. Okay, so whether it's you left a message and don't get a call back right away, and the apartment's flooding, or the landlord says, you think it's a flood? I don't think it's a big deal, which would be a pretty crazy answer for a landlord since it's their property. But we're giving different hypotheticals.
Mhm.
You've done your part in informing the landlord. From then on, you can call a plumber, have them come, fix the pipe. The plumber, of course, will give you a written bill, and that's your proof that you paid the plumber. On the way, also, you can take a picture. It's a pretty good idea to take a picture, but a plumber is not going to say I repaired pipe in kitchen or whatever if there was nothing to repair. So that's on itself pretty good proof. Um, if you're trying to reach the landlord, for the first part, just going back to the first part, because
Mhm.
one of the things the landlord could say is, well, you didn't even give me a chance. I'm not going to pay because you didn't give me a chance to do the repair. And I could have found a plumber for less. Or my concierge in my other building could have done it. They could say you didn't inform them. So it's always good to have proof, and you don't have time to send a registered letter here. So if it's possible, you can have somebody standing beside you when you call the landlord. Put them on speaker so they're a witness. Put them on speaker when you leave a message on the landlord's answering service. Like whatever you can do to prove that you gave the notice. Or if there's a rental office in the building, it's a big building. There's a rental office. If it's possible, go with someone, or take a picture of the person, which it'll have the date, so it shows. Look, I was in the rental office that day, so although I can't, or for that matter, since all our phones now can record, go and record yourself telling the person that the pipe is broken, and record their answer, and then you've got good proof. So whatever you can do to prove that you notified, because one of the arguments the landlord could use against you is, well, you didn't really inform me, so I didn't have a chance to do the repair myself, so I'm not paying.
Okay, so keep your receipts
No,
and
absolutely. And then
keep
send
your
them, you
record.
send it when you pay your rent. Let's say you pay, $250 to the plumber. I think that's about the minimum now for having a plumber come and do anything. Um, you say, look, my rent is usually 750. You describe the whole thing, everything I've talked about, how you tried to inform them and so on, what the plumber did. And here's the plumber's bill. It's $250. Therefore, I'm paying you 500.
Great. Okay. So someone had a very specific example of what you were referring to as normal disturbances and who is responsible for what. Um, so let's say in your building there's someone who in the hallway is always on their speakerphone, so the entire the entire floor can hear the conversation. Do you have to deal with that one on one with the other tenant, or do you have to go to your
No.
landlord and the landlord deals with it?
Okay. You don't have to deal with the other tenant. You don't have a contract with the other tenant. You have a contract with the landlord, and landlord has a contract with that tenant. The contract being the lease, of course. So now we're dealing with a human situation. So uh, it's possible that the person just doesn't realize. They could think, okay, I don't want to disturb my wife or my roommate, and unwittingly be disturbing 10 people instead and not realizing it. So depending how you feel about it, you could definitely go up to that person and politely say, you probably don't realize this, but, talking on the speakerphone, the sound insulation isn't that good. We can all hear you down the hall. And maybe the person will actually correct their behavior. So that's an option. But if you are shy or scared or whatever about doing that, you can go directly to the landlord and say, this is what's happening. If many of you, and this is a general principle, there's strength in numbers. If there's 6 of you on the floor, 1 is causing this disturbance, 5 are being disturbed. It would be great if all 5 of you would sign this letter and say, we're being disturbed by this person. Can you please talk to them and end this disturbance? So you have the option of doing either, dealing one-on-one. We're in a free society with free speech. As long as you're not threatening somebody or anything, you're talking politely to them, it's absolutely fine. It's really not a bad idea if you feel comfortable doing it, or going directly to the landlord.
Someone asked a question about landlords being obligated to keep your dwelling to certain standards. So this person asks, in extreme cases, can you claim loss of engagement of the premises if repairs are not done?
Loss of enjoyment, I think they mean, not engagement.
Oh, yeah, sorry, it's my handwriting. I can't even read it.
Okay.
It's enjoyment. You're absolutely right.
Loss of engagement would be more in family law, I think.
Okay.
Yeah. Yes. No. Absolutely. If there are repairs that are not urgent but are affecting your enjoyment, so you could imagine, let's say, a light fixture that doesn't work. So, like a few hours of the day, it's too dark to enjoy that room of the house. Constant dripping, which is in your shower, which is not stopping you from using your shower, but is maybe keeping you up or making it harder to get to sleep. Things like that. Absolutely, those are the different recourses that I talked about. That first of all, you would inform the landlord that this repair should be done and give them 10 days. If they sadly don't act to solve the problem, you would contact the rental board, and they would go through different recourses, such as reducing your rent until the repair is done, maybe giving you something in damages for what you've already suffered. Let's say this has been going on for a while, and an order that the landlord do the repairs, and so on. So reduction of rent or damages for lack of enjoyment, loss of enjoyment, absolutely, that is a possible. You can possibly be compensated for that.
There seems to be a bit of a fear element to contacting the TAL or the rental board, as though it's this big bad monster, if you will, because it's very intimidating. So I guess my question to you, Rick, is, in your experience and also in your previous career life, how scary is it contacting the rental board?
I don't think it's scary at all. I did have, even prior to Project Genesis, I had a period in private practice where I appeared regularly before the rental board. As a tribunal, it's very informal. It's not like, what you see courts look like on TV, on Law and Order or whatever.
Yeah.
Very informal.
People's court.
Yeah. Nobody like Judge Judy barking at you.
Okay.
And the people that you would contact, let's say somebody has a repair situation, they want to discuss their options. They're not like judges, they're not actually lawyers, they're people who are trained to help the public to fill out forms, to give them information about their rights. Now, with all that said, anytime you're in a confrontational situation with somebody, the relationship changes, and this is an unfortunate thing. And sometimes the parallel is done, or the comparison, with family law. Family law, you go to court, you get divorced, you separate. Housing law, you go to court, you go to the tribunal, you still have to live together. In a sense, you have still, the relationship continues maybe another 5, 10, 15 years while you're living in your apartment. And the reality is, it's a human relation, and it does make things difficult. And that's why it's unfortunate that a lot of people don't exercise their rights. And that we can't get around that. What you're into, you're kind of escalating the situation to something of a confrontational relationship, even though the setting, if you end up going to the tribunal, is quite informal. But going back to the original question, if you're just at the stage of exploring, getting information, it's really not an intimidating thing to contact the TAL, speak to someone, get information, or visit them to sit down with somebody and get information.
Okay, so people shouldn't be afraid of quote unquote rocking the boat, I guess.
Well, that's where we go one step further and we're entering into a confrontation.
Mhm.
I mean, I don't think many landlords will get really upset. This is a human relations. So
Mhm.
my answer is no better than anyone else's answer by getting a letter just saying, or getting a phone call first. Like, there's this repair to be done. And the landlord doesn't do it. Then getting a letter, but still no court, no tribunal, nothing. But once you pass that, you are kind of rocking the boat and you have a choice to make. It's your right. I would encourage people to exercise their right. If I can say one thing out of 30 plus years, as Ruth pointed out, of legal experience in different settings, generally people's rights are more respected when they speak up. There's a saying, the squeaky wheel gets the grease, and it is true in a lot of situations. Generally, people's rights are more respected when they stand up for them than if they accept for their rights to be not respected by repairs not being done or abusive rent increases that they refuse and so on. So I encourage people to exercise their rights, but I do recognize we're in human situations and confrontation is not always easy.
So it is what it is, kind of thing.
Very good summary.
Got it.